In this, our last lecture on juries, we're going to be looking at some jury reforms. Before we do, though, I just want to share with you one right that juries have that they're often not aware of, and that is this idea of jury nullification. The jury, in sort of jurisprudence in the study of law, the sort of philosophy of law, the jury is seen as the conscience of the community. And as the conscience of the community, they have unrivaled powers to basically ignore the law, if that's to makes any sense. And basically, what it is, it's this power to acquit defendants despite evidence and judicial instructions to the contrary. Jury nullification, you can see it happening sometimes. For example, when juries in the 200 years ago in the North refused to find people guilty who helped slaves escape from their masters. So that was jury nullification, even though you had absolutely the evidence to show that they helped slaves escape. Some juries would not convict. On the contrary, sometimes down in the South during the 1950s, juries would acquit completely guilty individuals who had killed African Americans. So this is a jury nullification, the ability to be the conscience of the community. And it permits acquittal of defendants thought to be guilty, but morally correct. Okay? And in civil trials, to award damages that serve some moral rather than some legal cause. Interestingly enough, in 1895, the Supreme Court ruled that jurors were supposed to follow the law, but that broke down in 1968 with a Supreme Court decision that opened the door for nullification. In other words, giving juries the permission to ignore the law and to vote their moral conscience. So let's just take a look at a couple of studies that have looked at jury nullification. One of the first, I should have mentioned, one thing that's interesting about this nullification is that the courts will not tell the jurors that they can nullify. So this is a right that juries have, but the courts don't want to say you may nullify. And of course, the belief by the courts is that if you tell jurors that they can nullify, that they will nullify. Okay, so let's take a look at one of the first studies that looked at jury nullification. This was done in 1988 by Irv Horowitz, and he was looking at whether in what kinds of cases juries might nullify, and whether instructions to nullify increase nullification. So what he did was he varied the types of cases, and he had people were assigned to one of three different types of cases. In the drunk driving case, a drunk driver kills one and injures another while driving home from a party. In the euthanasia case, a male nurse who had cared for a terminally ill patient for a really long time was accused of a mercy killing. And then in the third case, it was illegal weapons possession, and this was a mentally disabled convicted felon who got a gun because he thought he needed it for a mail order detective course that he wanted to take. So you have three different cases. All three of these cases weigh towards guilt. And the other thing he varied in this case was nullification instructions from the judge. Half of the participants were told that they had to give respectful attention to the law, but that they had the final authority to decide to apply the law. They were explicitly told that they could acquit the defendant. And so what we're basically interested in is their decisions and their guilty verdicts in these three different cases. So what was the impact of nullification on these three different cases? First of all, I want to show you that the type of case made a big difference. Instructions also made a difference. So what you see here is that, oh, by the way, let me orient you here. The greater numbers is towards guilt. Okay, so the higher the number, the more towards guilt. So you can see in the euthanasia case and in the possession case, you have, with nullification, people were less likely to find the defendant guilty. And so the nullification instructions led people to use their moral judgments. And as you can see, for the sympathetic defendants, such as the convict, the mentally disabled convict, there was a lot of sympathy, and the guilty verdicts reduced. Also in the euthanasia. However, you can see that nullification had a boomerang effect in the drunk driving case. Given permission to just go hog wild, they were slightly more likely to say, yes, I'm definitely sure this person is guilty. So what this early study showed is that, yes, nullification instructions can affect people's decisions, but also that people don't just simply nullify if given the choice to nullify. They really are paying attention to the facts of the case. Okay. Here's another study that was done by Horowitz and his colleagues, and this time they used a civil trial. And again, they were looking at how nullification in a more subtle way may affect decisions in a civil trial. So one of the most important tasks in a civil trial is to determine negligence. Who was negligent in the case, and to what extent each party was negligent, because negligence and blame are often central to how much money you're going to get in damages. So what they did in this particular case is they presented mock jurors with a civil trial, and what they did was they varied the negligence rules. They used 3 different rules, and people were assigned to one of 3 different rules. In some cases, the rule was unfair to the plaintiff, and in some cases, the rule was unfair to the defendant. So let me just tell you what those rules were. So again, 3 different rules. One rule is what we call the comparative negligence rule. Now, this particular rule says that you reduce the monetary award to the plaintiff in direct proportion of blame the plaintiff should receive. So let's just take an example. Let's suppose that you thought the right award in this case is $100, okay? But you also feel that the plaintiff in this case shared about 30% of the blame for what happened. So what you would do in this case is you would reduce the amount of money that you give to the plaintiff based on the percentage of their negligence. So instead of giving $100, because they were 30% responsible, you would give them $70. This particular condition is sort of the baseline condition because it's fair to both parties. The second negligent rule was called contributory negligence. And this one, any negligence on the part of the plaintiff means no damages to the plaintiff. So if the plaintiff was even 1% responsible for their own injury, then they get nothing. And the last one is what's called strict liability. And this is actually, as you can tell, the contributory is sort of unfair to the plaintiff. The strict liability will be unfair to the defendant. And this says any negligence on the part of the defendant leads to a full damage award to the plaintiff. So you can see there's some unfairness to one party or the other in these rules. So let's take a look at the case that they used. This was a civil case where the plaintiff was suing an auto manufacturer for $1 million in damages. The plaintiff alleges that the manufacturer was negligent in designing the car. The car had a defective fuel filter, which caused a gas tank explosion, which killed the plaintiff's wife. And an expert in the case testified that the defective filter caused the explosion. Okay? The defense agrees that the filter was defective, but what they did was they cited the efforts that they made to recall all the cars with the filter. The manufacturer shows that they made efforts to contact the plaintiff about the recall. Okay? This is a very tough case. It's not very clear-cut. And so what happens to people when they have these different negligence rules? And do they nullify? So let's take a look at the results of this study. So first I'm going to show you the negligence ratings for the plaintiffs. Okay, how negligent was the plaintiff? And look here, you can see that there are some difference here that suggests nullification, but you can't really tell for sure. But you can see that the plaintiff gets a lot more negligence in the strict than in the contributory. The contributory, remember, if there's any negligence on the plaintiff's part, they get nothing. Okay, so you can see that there's a difference here, but you can't really honestly tell whether there's true nullification going on here. It's suggested. The best way to do this is to look at who assigned no blame to either the defendant or the plaintiff. So these are the people that assign absolutely no blame to the defendant or the plaintiff. And here are the results of that. Now, by the way, I want to mention that I don't have the comparative on this chart because not one single person in the comparative condition said one party or the other was not at fault. But you can see right here that over 40%, about 45% of the participants said the plaintiff had no blame in the contributory condition. That was because they wanted to assign this guy some damages. And so in order to do that, they said he had no blame. In the strict, you see that 20% said the manufacturer had no blame, again, because they didn't feel it was right to assign the full $1 million to the plaintiff. So what people are doing is they're justifying their moral, they have a moral feeling that things should happen one way or the other, and they justify it by assigning no blame in the conditions where they want to. So in terms of jury nullification, I've shared with you a couple studies here, but basically there's consensus that jurors may disregard the law when they think it's unfair. In the case where there was strict liability, or in the case where someone with a mental disability does something that, although is unlawful, they feel some sympathy for. We know that jurors are more likely to nullify if given permission or given arguments for nullification. So an attorney might, in closing statements, tell the jury that they can nullify, okay? Especially if they have a very sympathetic client. Also, jurors may justify their nullification by changing perceptions of the case to be consistent with the law, which is what you saw in the civil case. I'm sure none of the jurors thought they were disregarding the law. In fact, they just said, no, I'm following the law. No, the plaintiff had no blame, or no, the manufacturer had no blame. So those are both different types of nullification. Okay, let's turn our attention to the last topic I'd like to talk about in this section, and that's jury reforms. The task for the jury is pretty complicated. There are lots of things that people have pointed to and said, you know, we need to make this easier for them in terms of understanding the information, understanding instructions, and there have been lots of proposals. Some of the proposals are uncontroversial. Uncontroversial proposals are things like allowing jurors to take notes during trial, giving them pre-instructions letting them know, kind of giving them a framework before the trial gets started on what first-degree murder is, second-degree manslaughter, and so forth. Another one is providing jurors with written copies of the judge's instructions so they don't have to try to remember what the judge told them. Other jury reforms are kind of radical. Here are some that are considered quite radical. One is to allow jurors to pose questions during trial. Another is to simplify the language of jury instructions, or to allow jurors to discuss evidence during trial. Now, some of you may be wondering, why is simplifying the language of jury instructions so radical? Well, believe it or not, jury instructions are very, very important because faulty instructions can be grounds for appeals in cases. And so if you're suggesting that the way that we've defined reasonable doubt is wrong and it needs to be simplified, it could open the door to appeals. So it makes it kind of radical. Allowing jurors to pose questions if they don't understand something that's going on, allowing them to ask a question. Now, this is considered quite radical, but in the Aurora shooting trial, there was a rather progressive judge presiding over this case, and he did allow jurors to pose questions. But jurors don't usually typically just simply get to raise their hands and ask questions excuse me, I don't understand what that person just said. Rather, what they do is they tend to write the questions down and submit it to the bailiff, and it's given to the judge, and then the judge will answer the question if he thinks it's relevant. Okay, so these are some of the jury reforms. And there are places around the country that are trying some of these reforms, and some that are even more radical than this. Arizona, for example, has led the way in trying some of these modifications and testing to see whether in fact they make a difference, which is great. But most of what they've been doing is doing field studies, and field studies are very hard to do because it's hard to control all the variables in these different cases to see whether the reforms are really working. So one of the ways to take it is to take it into a lab. I know that's not as realistic as a field study, but you can control so many more things in a laboratory experiment that you can't control in real life. So let me share with you a study that we did in our lab, looking at 2 jury reforms. We decided to do note-taking as one, which is an uncontroversial reform. There are pros to note taking. People say that maybe, taking notes will help you encode and retrieve information, especially in a long trial or a trial that has a lot of complex information. The cons might be that maybe the notes could be too influential. So you didn't write something down and then it's completely gone because you're relying so much on your notes. Also, note taking might be distracting. So pros, cons. Okay. Another reform that we decided to study was one of the more controversial, which is discussion. Discussion allows the jury to talk about the case, maybe at different points during the trial. And some of the pros are that it might improve understanding of evidence. So if jurors can hash out the evidence pretty close to when they hear it, maybe it'll improve their understanding. Remember, we talked about deliberations before, and that it improved your reasoning. Maybe it helps to do it multiple times. You might have an increased recollection of the evidence, because since it can be discussed when it's heard. Something you heard at the beginning of the trial might be completely forgotten by the time you get to deliberation. And of course, it might make the group more cohesive. The cons to discussion, maybe the jurors will make premature decisions. If they hear the prosecution first, they might start to lean that way, and maybe that will lock them in. Think about the satisficer, that model. They lock into one story and then make a decision prematurely. Second thing, it may diminish the quality of the deliberation when you break it up like that. And again, who knows? And then finally, instead of being more cohesive, there's a risk that you can actually polarize the group. If you got the group that one side feels one way and one side feels the other, discussing multiple times might actually polarize the group rather than making them more cohesive. So what did we do? What we did was we looked at to what extent note-taking and discussion impacted verdicts and evidentiary reasoning. And when I say evidentiary reasoning, we're using that same reasoning tool that I discussed in the previous lecture, reasoning about the evidence at trial. So what we did was we randomly assigned people to one of 4 trials, and it varied on, you were either in the note or no note condition, and you were either in the no discuss or discuss condition. Now what we did was we used the same trial that I described to you in the last lecture, the Colorado, it's a murder trial, the Colorado versus Sandoval trial. And people in the note condition were given a blank sheet of paper and told that they could take notes. The discussion, what we did was, the trial was an edited trial. It took about 1 hour. And what we did was, after the prosecution presented their case to the participants, we grouped the participants and we took them to a separate room. The people in the no discuss condition were told that we were taking a short break, but not to discuss the case. The people in the discussion condition were told we were giving them time to discuss the case. So discussion, no discussion. And then following the completion of the trial and the jury instructions, all participants were given 10 minutes to deliberate. And then after the deliberation, we gave them the reasoning task, looking at the degree to which they were theory evidence coordinators at this point. So let's take a look at the results of what we found here. First of all, oh, sorry, following trial presentation, the case reasoning was assessed. Okay, so let's take a look at the effect of discussion. So remember, higher scores indicate better reasoning about the case. Surprisingly to us, the people in the discuss condition had significantly lower evidentiary reasoning scores than people who were not allowed to discuss and had to actually deliberate all the way at the end. So participants in the discussion condition scored lower on the reasoning task than those in the no discussion. And with regard to the notes, we found basically no difference in the no notes and notes condition. And in fact, the people in the no notes condition were slightly better than the people in the notes, although that wasn't significantly different. And to be honest with you, because we're college professors and we're used to students taking notes, we were really kind of shocked at this, that notes didn't help. So what we did was we went back and looked at the note taking. Remember I told you that we gave them blank sheets of paper and asked them to take notes? And what we found was among our participants, even the people in the notes condition, 36% of the people in the notes condition didn't take any notes at all. Okay, so although they were allowed to take notes, they didn't take notes. And so what we did then was we went ahead and decided to kind of score this a little bit differently. And we went and we counted the number of words, the volume of notes that people took to see if it was associated with your reasoning score. And in fact, that's where we found the difference. What we found was that as a person took more notes, the more notes a person took, the higher their reasoning score was on the evidentiary reasoning. So taking notes and taking more notes did help, but it didn't do any good because, in fact, we didn't require people to take notes. So I guess the moral of the story on notes is that notes can help, but if just giving people permission to take notes may not be enough. And, you know, what good does it do to force people to take notes? So our experiment on jury reforms didn't really come out very positively. We know that jury reform is a major topic in psychology and law and in the legal system, but we don't have a lot of data. And what little we have may suggest that, you know, some reforms may make sense. They have face validity. However, we really need to test these out because some of these ideas may not actually help jurors. And in fact, may hurt jurors' ability to understand the case. And it's very important also to gather data to help the courts in their quest to make the task better and easier for jurors. Okay? So we're all done with the jury section of the class, and I hope you have a better understanding of some of the many different ways you can look at how jurors make decisions.